So if you could give us an introduction of yourself and general information about you and your firm.
Hi, good morning, Damon. Thanks for having me. I'm so happy to be here. My name is John Hilton. I'm a life and legacy planner. A lot of people don't know what that means, but essentially, an estate planner that deals not just with death, but with planning for our clients' entire life, from the age of 18 all the way through and beyond death to capture their life and legacy for multiple generations. And this from a personal standpoint, um, I was a flight paramedic for 20 years. And after that, I went into hospital administration. And through a turn of events, I decided to go to law school. And I discovered that this was a tool that I could use to really make an impact on people's lives. And so I have been doing this type of work for almost 6 years now. It's just such a passion of mine to be able to get into people's lives, hear their stories, and be able to help guide them in creating this life plan and this legacy for them.
Excellent, excellent. And so, what are the things that you offer as far as helping people protect their legacy in their life? What are the mechanisms or the tools that are used for that?
So it actually starts at age 18. As soon as somebody turns 18, they are an adult. And so kids going off to college, for example, they need documentation to be able to allow their parents or other people in their lives to be able to make medical decisions for them. They need to have documentation to allow someone to make financial decisions for them in the event that they should become incapacitated, have a bad accident, or not be able to manage their affairs for some reason. And we see this, unfortunately, it's way too common, but we see these college students heading home for spring break or heading back to school. They have an accident. They're 18, 19 years old, and they don't have anybody named to step in and manage these things for them. So it starts there. And then all the way through marriage and having children. A lot of people don't think about what would happen to their children as parents if they were not able to return home that night. Mom and dad are out on a date, young child is at home with a babysitter, they're involved in an accident, they don't come home. What happens to that child? And that child, if there's not somebody named with proper legal authority to take custody of that child could end up in the hands and home and care of a stranger, because the Department of Child Safety, or some people call it, Child Protective Services, they have a duty to ensure that that child is in a safe environment. And that babysitter doesn't have the legal authority to hang on to that child for a day or two or a week or however long it may take until mom and dad are back in their lives. Um, and even, the worst case scenario, mom and dad are killed or permanently incapacitated in an accident. Who will be that child's permanent guardian for the rest of their lives? And those are important decisions that parents have to make. You don't want just anybody stepping up and saying, I'm going to raise that child, because, all of us as parents, we have our values and the things, the way that we want our child raised. We have spiritual values and social values, financial values, education, all those things that are so important. And so planning for that unlikely but possible eventuality that something could happen, knowing that you've got the right people named who can step in and have the legal right and nomination by you to petition the court to have guardianship over your child and raise your child in the way that you would want them raised. So that's just the beginning. As we go through the life cycle, as our children are going off to college, making sure that they have those documents I was talking about before to protect their health care and their finances as they become young adults. And then as we move into our older years, ensuring that we have a plan to pass our assets on to our children and do that in a way that is protected for them, so that in the event that our child also runs into difficulties as an adult, whether it's credit issues or divorce or things like that, that the assets that you're passing on to them are protected and they're not caught up into those events. As we age, we face the possibility of becoming incapacitated and needing in-home or skilled nursing care in a facility, and ensuring that there's a plan in place that allows us to pay for that in such a way that doesn't drain our life savings, and in a way that we would want to be cared for. So when I talk about life and legacy, it starts from early in life all the way through to ultimately to when we die and we pass those assets on to our children. And when I talk about legacy, a lot of people think about legacy purely in financial, but I believe every person, and more specifically, maybe every family, has a story to tell, and that story is more important than just for our lifetime. It carries on to future generations, and part of what I like doing with families is capturing their story and letting that become a part of their legacy for their children and grandchildren and for future generations.
Excellent. And so with all of that, what is the tool or the mechanism that you most often use to help people with their life and legacy planning and avoid a lot of the mishaps that you were just referring to?
Sure. Um, there are a lot of tools that we use. The one tool that I believe most effectively allows families to capture their legacy and to pass their assets on to children, and protect them, is through the use of a revocable living trust. That's not to say that everyone has to have a revocable living trust, and that if it's not the right call for you, there are other mechanisms, but the most effective way to do that is through a trust.
Okay. And is there only one type of trust, or are there multiple types of trust?
Yeah, actually, there are numerous types of trust. The most common that we use is the revocable living trust, and that's a type of trust that during your life, you have total control over all of your assets. You can put assets into the trust, you can remove them, sell them, give them away. You're in total control of your assets throughout your life. But there are times when there are what we call irrevocable trust that we use for other types of planning. When we have really like ultra high net worth clients, sometimes we can take a portion of their financial assets and put them in an irrevocable trust. There are a lot of benefits to that for some people. It's pretty rare. We know that those ultra high net worth clients, make up a very small percentage of our population, but there's that type that has some tax benefits, allowing assets to pass like to grandchildren and future generations with some tax benefits. However, that type of trust people are often a little concerned about because you actually have to give up control of that asset during your life. So ultra high net worth, if you got an extra $10 million lying around that you want to protect, for future generations, that might be a good call for you. But I would say, for well over 99% of our clients, a revocable trust in which they maintain control of their assets throughout their life is the preferred. Now, another type of trust that we often deal with, just as a side note, I have a son with autism. He's 33 years old, and he's dependent on public benefits. So another type of trust that we'll use is what we call a supplemental needs trust. And that allows assets to pour into that trust for my son's use, for example, without compromising his eligibility for those benefits. And so anyone who has a child with any kind of disability or other type of special needs, that's something that we recommend to them to ensure that they can still inherit, still maintain their quality of life, have access to the comforts of life, and still have access to those public benefits.
Okay, excellent. And so you mentioned that there is you can use trust to protect your assets or to help yourself in as far as your legacy planning goes.
Mhm.
But you also mentioned that there are other mechanisms. What are those other mechanisms that can be used other than a trust?
Well, sure. We have, clients who come through our office that, maybe they just don't have enough assets to really justify the investment into a trust plan. And so we will work with them to ensure that those assets pass to their children or other beneficiaries, through beneficiary designations, beneficiary deeds, a will. Um, and even with that, that doesn't mean that that family doesn't have a story to tell. So capturing that legacy for them, and it doesn't matter if you're living on $10,000 a year in Social Security or $10 million a year in investments. You have a story that is so unique to you and your family, and that's your legacy. And I'll tell us a very quick story to illustrate this. My dad was a pastor of a church. I grew up sitting on the front pew with my mother every Sunday morning, every Wednesday night, listening to my dad teach the Bible. My dad was a teacher and a true pastor. He really cared about his flock. He wasn't a fire and brimstone preacher. He really just was like to just take care of his people. And his special gift was going into these churches where there were three parishioners on Social Security, and the church was about to go broke, and they were going to close it down. And he would go in and build it up and bring in young people and families and shepherd them. And so I grew up, watching that and learning from my dad how to be a teacher and how to care for people and the value of giving. And later on, my dad left the pastorship and became a missionary, and so we ended up down in Mexico, doing a lot, creating a lot of missions and things like that. And when my dad died about 20 years ago, when I went to his funeral, there were people in that chapel that I had never met. I mean, it's just all these people. Like, who are all these people? And I asked them, like, how did you know my dad? And I was getting all these stories from people about, well, I was in really bad shape. I didn't have a job. I was losing my house. Your dad gave me work, and he allowed me to maintain my dignity and earn some money and get back on my feet. Or your dad would he would feed me. He'd bring me a meal every day because he knew that I was struggling. And so that was my dad.
Right.
So when my dad died, they didn't have anything. My dad gave everything away, and
Mm.
they were renting a house. My mom and dad were, and uh, he was laying there in the hospital bed, and I was talking to him, and he said, "John, I have one regret in life." I said, "What's that, Dad?" And he said, "My only regret is that I didn't leave my children $5,000." And that to him was just such a huge amount of money.
Mm.
And I say, "Dad, you don't have to have any regrets, because what you left me was your legacy. You left me with that spirit of helping people and reaching out to people and being able to teach people what's important to them. You left me a legacy of being self-sufficient and of learning how to do so many things in life, because my dad was kind of a handyman, and he was always having to do odd jobs to help support the church. And
Mm.
I would go with him. So the time I was 4 years old, I was out there with him, handing him tools and learning how to build and do home maintenance and projects like that. And I said, "You've left me so much more than any amount of money
Mm.
could ever equal."
Right.
That's the legacy. So when I talk to people, for me, capturing their legacy isn't about ensuring that all of their financial, assets are there to support their children from multiple generations. It's about capturing those stories and making sure that their family recognizes that legacy, and encouraging people, that it doesn't matter if you've never thought about your legacy. You're going to leave a legacy one way or the other.
Mm.
It can either be intentional or it can be accidental,
Right.
and
Right.
it's never too late to make it intentional and to live your life with purpose, to have that legacy that you leave behind. And so for me, the documents that I prepare, whether it's a will or a trust or beneficiary designations, those are simply building blocks, that are, whatever's appropriate for that particular family. But upon those building blocks, upon that foundation, is what we're able then to build, because whether there's peace of mind, the family knows how things are going to happen, the children know, the parents know, they know that if mom and dad end up in a skilled nursing facility, that there's a mechanism in place to pay for that without having to, impoverish the family. So for me, that those are the mechanisms that I use, is finding what's right for the family in order to give them that peace of mind and allow them to focus on family unity and building legacy and avoiding the conflict that comes from so many estate plans that people do.
Okay, that's a beautiful story, by the way. Thank you for telling it.
Yeah, I
Um,
mean, it is. It's so close to my heart, and it's I tell it to everybody I can, when we're talking, because I think it's really indicative of you don't have to have money to have a legacy.
right.
You just capture your story and live life with purpose.
Good. And so with capturing the story, and there's a lot of people who may watch this video who don't really understand the differences between, let's say, a will or a trust or a living, what is it called? A living, what is it? Power of attorney, a
Yeah.
medical power of attorney, all those sorts of different things, mechanisms you're talking about that you mentioned a moment ago. Can you just do a brief rundown on what is the difference between all of those things, and why it's important for somebody to have all of those things?
Sure. Let me preface that answer with a quick discussion on probate.
Okay.
Um, so, and it'll make sense as
Yes.
we move forward. But
Yes.
um, just to kind of give you, some foundation, um, typical lawyer work creates conflict,
Mm,
whether it's negotiating a contract, or creating a will. The way the legal system is has evolved over centuries is that inherent in what we do is the potential for conflict. And so when you create a will, even, you're creating potential for conflict, because when that person dies, and that will has to go to court to be probated, there is the potential there always for conflict to arise in the family.
mm,
And I talk to parents all the time, like, well, that's never going to happen to us. Our children, they all get along, they love each other, they all want what's best for each other. And I was like, what, I believe you, and I believe that that's true today.
right.
But our probate courts are full and overflowing with families who are fighting over stuff after mom and dad are gone. And so probate is really just the action of taking that will and putting it under the jurisdiction of the courts, and having the courts oversee the distribution of the assets, of the person who has died, to the people named in the will. But it's actually an errant conflict. The first people that have to be paid are your creditors, and so creditors come in and they want to take their piece of it. And you have, family members who think the will isn't fair, and you've got, it's just, the conflict that arises out of probate is destroys families, actually. And I have clients come to my office, and many of them come see me and they say, John, I want to create a trust because I just probated my mom's estate, and it was the most horrible thing I've ever done. I don't want my kids to go through it. So probate is this process of putting this estate under the jurisdiction of the court, and creating these wills, like most estate planners do. Um, is just like promulgating that conflict.
Mm.
So when we work with people, my goal is with every client is to create a safety net for their family with documents and plans that don't allow anything to fall through that safety net. So it might be that a will that is going to have to go through probate is what that family feels is appropriate for them. But along with that, then some of the other tools we use, like I said before, are beneficiary designations, where anything that has a beneficiary does not go through that court process. So that involves a beneficiary deed on your home, beneficiary designations on bank accounts, beneficiary designations on retirement accounts and life insurance policies. And so we'll work with families to make sure that all of those things have the proper beneficiaries named, and then we can get around that court process. Every estate plan has three critical elements, and one is either a will or trust, one is a financial power of attorney, and the other are healthcare powers of attorney. Those are the three essentials. So a healthcare power of attorney is where you name people who can make medical decisions for you if you are incapacitated and unable to verbalize your decisions or unable to make decisions for yourself. And in that healthcare, we call them healthcare advance directives, and that includes like a living will for decisions to be made at the end of your life, a mental health power of attorney in case you develop a mental health disease. But you're giving your designated agents instructions on this. These are the decisions I want you to make. These are my values. This is what I believe in. If I'm not able to make these decisions, I want you to make these decisions for me. When you don't have those in place, oftentimes we'll find that family members will have to go to court and get guardianship in order to be able to make some of these tough decisions. Or we'll have family conflict because no one's in charge of making decisions. The family will gather at the hospital, and half the family wants one action, half wants the other, and now they're fighting. And so having these documents, again, so much of this is about maintaining family unity and making sure that your wishes are always carried out. The other document is the financial and personal power of attorney. And this is a document that in which you name people who will make financial and personal decisions for you in the event of your incapacity. If you have a stroke or a head injury or any other situation in which you're not able to manage your financial affairs or personal affairs anymore, you name people that you trust to do that, and they have a fiduciary duty to carry out your wishes. Again, very important decisions. We have a lot of families who assume that they should name their oldest son to be their financial power of attorney agent. Their oldest daughter should make all their healthcare decisions. And so we work with families to help them understand that that's not always the best decision. It's not about protecting your child's feelings. It's about ensuring that someone you trust implicitly is going to carry out your wishes. So those are the three, if you will, legs of the stool, having a will or a trust, a financial and personal power of attorney, and a healthcare directive, healthcare power of attorney. In addition to that, we talked about if you are a family with small children, we have what's called our Kids Protection Plan. And in that we do guardianship nominations in the event that the parents are incapacitated or die before that child reaches the age of 18. We do short-term custodial appointments. So, kind of take that scenario I talked about earlier. where mom and dad are out at a date and their child is home with a babysitter and mom and dad don't come home that night. We help the family identify what we call first responders that can be at that child's side within 20 minutes
Mm.
with proper documentation to show law enforcement or the Department of Child Safety representatives that I have been given legal authority by the parents of this child to take them into my custody in the event that they are not available.
Wow.
And the whole idea here is you make sure that child never ends up in the home or care of strangers,
Right.
that they're always in the care of people that know and love them and will care for them and comfort them and make sure that they're safe and properly cared for during that time. So um, yeah, we got those, and then as like I said before, as we start moving into our older years and the possibility of long-term care or skilled nursing care comes into play, we had a whole nother set of planning and documents that we do to ensure that that's properly paid for without draining your life savings.
Okay. So, with your experience in this field, how often has a situation arisen to where somebody had a default? And what I mean by that is, they didn't have these things in place, and it defaulted, as you were saying, maybe to the oldest son or the oldest daughter, and they were reacting in an emotional way instead of in the way that maybe would have been congruent with the wishes of, let's say, the person who is maybe incapacitated or have, some kind of issues, mental issues, or whatever the case may be. How often have you noticed that it has defaulted to somebody who is not really the individual that you would want to have take care of some serious matters,
Mhm.
and it kind of hasn't worked out the right way?
Well, fortunately, I don't run into that very often because my mission in life is to get out and educate people about this and make sure that they get this planning in place. And so the people that come to my office, very often they come because they've heard me speak and they are coming to get those plans in place. But let me tell you a story. It's not my personal story, but it was back, I guess about 10 years ago, a family traveling through Arizona. They were from California. They were involved in an accident. Mom and dad were both killed, and they had three small boys who survived the accident.
Wow.
And so the mom had two sisters, and these sisters were fighting over the custody of these children. And unfortunately, a lot of times these family disputes arise not because they are so keen to take on three kids that they didn't birth, but because often there's a lot of life insurance and other financial assets tied to the children. And so we'll see families fight for custody and control of the kids because that gives them access to the funds as well. And that's very unfortunate, but we see it happen. And so these two sisters are fighting over the custody and guardianship of these boys. Um, that legal battle lasted over a year. Over $100,000 was spent, and all that money came from those boys' inheritance from their parents.
Wow.
The sisters are not paying for it. It came out of those boys' assets that they inherited.
Wow.
And so all these legal bills and all this conflict, and the boys are being, they go live with grandma and grandpa for a while, and then they have to go live somewhere else, and then they're seeing all this fighting.
Wow.
So that is actually, unfortunately, not that uncommon. I just read another story. It happened just a few years ago, the exact same thing, where a dad was divorced from the boy's mom. She had severe drug abuse and mental issues, and dad and son were traveling through Arizona, got involved in an accident. Dad got killed. So now the question rises, does mom get custody of this child when she has so many problems of her own?
Mm.
She's a biological parent, but she's got, some mental issues and she's got some substance abuse issues. And if not her, who? And so again, this child was actually critically injured. He was in the hospital for a while in the ICU. And this is one of the cases actually where the Department of Child Safety came in and did a really good job of making sure that child was properly cared for and finding appropriate people. But they had to go through this process of eliminating mom as not being suitable, and then going out and reaching out to the family and figuring out, who would be willing to come in and take this child into their home and raise them for the rest of his life. But the key to that story is that mom and dad had no say so in who that person was.
Wow.
So they don't know, that child may be raised by someone who has spiritual values that are in direct conflict with theirs, or
Right. Right.
social values, and so that child's being raised by someone who's going to, provide them a home, but that child may not be raised the way those parents would have wanted.
Wow. Okay. Yeah. That makes a lot of sense. Thank you for clearing that up for us. And so, one of the questions we have is, does a living trust avoid estate tax? Help you or help one to avoid estate tax?
Sure. So the person who creates the trust during their life does not get any tax protection during their life. They don't
Mm,
get any creditor protection during their life. So the courts have made it very clear that if you owe taxes during life, the IRS can take them right out of that trust. If you have creditor issues, bankruptcy, the courts can go in right into that trust and take those assets. However, through a living trust, there are options that we can design into it that allow for, at the death of the first of the couple to die, assets can go into a tax bypass trust, a tax avoidance trust, so that the surviving spouse gets full access and use of all of the funds without having to pay estate taxes at that time.
mm,
And then there's actually even a mechanism where we can pass those assets down to the future generations and still avoid a lot of those estate taxes. So there's definitely, if you're in a taxable range. Now, as of today, the federal estate tax exemption rate is like $12.4 million, somewhere in that range. We have a few clients who that applies to, that we're able to help. uh, the majority of our clients are sitting in the air somewhere between, $500,000 to $3 or $4 million, and the federal estate tax exemption rate is not going to hurt them. At their first death, those assets can pass to the surviving spouse with no estate taxes. However, the current exemption rate of $12.4 million sunsets in 2025, and it will go back to its pre-Trump rate, because President Trump, when he was in, he's the one that raised it up, basically doubled it from where it was before. So when that exemption rate sunsets, it will go down to about $6 million.
mm.
And that actually is going to impact a lot of people who are sitting in that 6 to 8, $10 million range. And so we can take and shelter anything that those estate taxes would be due on in a special trust, that again the survivor has control over and access to the funds, but doesn't have to pay the estate taxes, and then pass them on to the future generations as well, with estate tax savings for them. Estate taxes are nothing, they're almost 50%. So, if you're sitting, if this exemption rate is $6 million and you're sitting on an $8 million, estate at the first death, you're looking at $800,000 in estate taxes.
Jeez.
And so, yes, it's definitely worth it to consider looking at mechanisms to be able to shelter some of that under the IRS rules. It's all above board. The IRS totally recognizes it and has approved it.
So, with that sunset date that you just mentioned, does anybody who gets their trust or these things in place before that sunset date, are they grandfathered in, or does it revert back to everybody for everybody?
Yeah, it reverts to everybody. So if we have a client, for example, right now that has an $8 million estate, and today they're not affected, and if one of those partners dies before that sunset date, everything's fine. But if they die January 3rd, after that sunset date, then that spouse is going to be hit with those estate taxes.
Wow. Okay. All right. Next question. What criteria do you consider when recommending a trust versus a last will and testament?
I love this question. Um, you know, there are a lot of estate planners out there who have these arbitrary numbers. Um, if you have more than $400,000, $500,000 in liquid assets, you need a trust, or and we see a lot of trust companies that are really more investment firms that create trust for people than actual planners. And they'll have these arbitrary numerical designations like, well, you need a trust because your estate's worth X amount of money. My criteria is I sit down and talk with the family. I look at their family dynamics and we get their story. And I love getting the family story because when the family tells me their story and I'm able to dig into it and really understand what's going on with their children, what's going on with their siblings, and what their financial status is, and all of that, I can help guide them to make the right decision, regardless of the value of their estate. If it really boils down to this, if the client believes that their estate is going to have to go through the probate process and they don't want it, then they need a trust. That's one criteria. Now, there are some, some clients. I had a client come to me one day and said, "John, I want a trust." And I said, "Okay, let's sit down and talk about it." This person was living on about $1,100 a month in Social Security. She had a rented apartment and a 15-year-old car. And I said, "Look, I understand you want to trust. Your neighbor has a trust. Your neighbor told you needed a trust. I can't in good conscience, do that for you and have you invest your money into a trust." And she definitely did not qualify in my mind for that. So, but that's kind of the exception. We do have, I got a client right now who owns a home. The home is paid for, doesn't really have any other assets, but is adamant that when he dies, he does not want that home to go through probate before it goes down to his kids. And so, we talked about it and he agreed that the trust was the best way to do that because the trust completely bypasses probate. There is no court involvement at all. And that's what he wanted. And so he was willing to invest a little bit more in getting a trust plan done, even though he has no cash assets to speak of. His daughter actually paid for the trust for him. And so, it really comes down to what the client values and what they want for their children. Because in the end, an estate plan, I should say a will or a trust adds no value to you today other than peace of mind. It adds value to your children and your heirs in deciding, do they go through that probate process or do we pass all our assets to them outside of the probate process, free of the courts? Just to kind of give you a quick example of that. And it's still answering the question about criteria.
Yeah.
But this is what I ask people. Probate is public. It happens in civil court. Civil court records are public records. Anyone can go in there and see exactly what you left your children, how old your children are, the value of your assets. It's time consuming. Probate, in a best case scenario, we can get through probate in 12 months on a very simple estate. More often than not, we're looking at 18 to 24 months. As we try to get assets liquidated and appraised and all of those things. It's expensive. On average, we see a probate, when you calculate in attorney's fees and appraisals, court costs, things like that, anywhere between $35 to $100 to $5,000 to go through the probate process. And like I said before, there's that inherent conflict that can arise in the family when people start having to go to court and look at these things. So in a trust, all of that goes away. It's private. Assets pass to your children, to your other beneficiaries, to heirs, whoever you name, completely privately. No one gets to know unless the beneficiaries share. It's extremely low cost at the time of death. Basically, there's an affidavit that a new trustee has to fill out. So we're talking a few $100s versus thousands of dollars at the time of death,
Mm.
and it avoids the family conflict because you've laid out in your trust all of your instructions for what you want to happen with your assets, where you want them to go, and there's so much flexibility in that. And so those are the criteria that I present to the clients and say, if you're okay with the probate process, you're okay with the publicity, with the cost at that time and the time, and these are the things that are not important to you, then that's fine. I'm happy to do a will for you. But if these things are important to you and you want to avoid that for your family, then the trust would be the answer. And so the criteria for me is really what the client tells me is important to them.
Okay. But I want to ask specifically at like what age? Because I know we talked about 18, and I know a lot of times people will say, "Well, I'm already too old for that," or "I'm too young for that," and they put maybe this age on it, or I haven't bought a house yet, so I don't need to get one,
Right.
or they put certain things in place in their own mind to say, "Well, I don't need one right now for this reason or for that reason." What would you say
Certainly.
to somebody who does that?
So I believe that um, from the day you get married, the importance of having an estate plan just gets so much higher.
Right.
Um, I talked before about being single and having your healthcare advance directives and your financial power of attorney in place. Those are important. But once you bring somebody else into that mix, we have a duty to ensure that our spouse, our wife, or our husband is cared for. And the best way to do that is to make sure that you got a proper plan in place. And I have, some young couples who clients, they don't have any children, they're recently married, maybe they haven't bought a house yet. But what's imperative is that at that point, they have a plan in place to ensure that life insurance, for example, has proper beneficiaries noted, and they've got their health care directives in place and their financial powers of attorney in place, and that as spouses, they are legally through documentation allowed to make those decisions for each other that are so important. And as their financial situation changes, I say that typically what I recommend to people is once you own a home, that home, you don't want it going through probate. Uh, Once you have any other assets, life insurance, even we take life insurance, so we can pass it straight through a trust and make sure that it's distributed the way you want it distributed. IRAs and 401k plans, retirement plans, by passing them through a trust, we have greater control sometimes over how those disturbances are distributed to the spouse or to the children. So it all starts with that young family. Now, is there a magic time? As soon as possible is my motto on that, to ensure that you're taking care of your spouse. When you bring a child in, as soon as possible to make sure that you have that child is properly going to be cared for. Again, life, a lot of young families don't have a lot of assets. They're still building. But so what they'll do is that, they'll supplement with a hefty life insurance policy, which is, I highly recommend that. And so, but the question I pose to parents and to help them make this decision is, young parents, you've got a $1 million life insurance policy because you want to make sure that your spouse and child are cared for. Both parents are killed in an accident. Now you got this 4-year-old child who is going to inherit a $1 million life insurance policy. Well, they can't inherit it at 4,
Right.
but guess what? At age 18, that life insurance policy is going to be handed over to them.
Mm.
You're going to have an 18-year-old kid with $1 million.
Wow. Yeah.
Is that what you want for your kid?
Right.
You know, and I was 18. Every one of my clients has been 18. We all know what we're like at 18.
Right.
And, we don't have our frontal lobes fully developed. Our gray matter is still white, and we don't have any common sense. And, we see it all the time in Hollywood with these young stars who are multimillionaires and their lives are ruined.
Mm.
And so I talk to parents about that. If that's not what you want for your child, if you don't want your child to win the lottery at age 18,
Right.
then we put a trust in place. That trust can hold that for that child, make sure that child is properly taken care of, that their education is paid for, that they have housing and they have food and their everything that they need throughout their life. But then when that child is old enough, they can get control of that life insurance money. So for me, it's never too late, and it's rarely too soon to start this process. And I do have a lot of clients come to my office like, well, we're we're in our 70s. We figure it's about time we get something in place. And I just like, well, thank God nothing happened over the past 50 years,
Right.
because we all believe and hope and trust that we're going to have long, healthy lives. Unfortunately, the lottery sometimes strikes, and it's just not not in our cards. And so we don't know when we're going to die. We don't know what assets we're going to have when we die. We don't know what the laws are going to be. So getting it done as quickly as possible. um, I'll never encourage someone to do planning that is uh, too advanced for where they are. And that's a great thing about planning, is that it's a plan and plans change. And so over the course of their life, as children come and as their financial situations change and as they get more equity in their home, they can always come back and make changes to their plan that make sure that it's always appropriate for where they are in life. I always tell people, you shouldn't go more than 3 years without revisiting your plan, because so many things can happen during that time.
Yeah. That's awesome. That's awesome advice. I remember when you were helping us get ours established, you were talking about just something as simple as our separate bank accounts. Some people don't have separate bank accounts, but when most people, when you first get married, you start out with your bank account and her bank account, and if you
Right.
don't join them, if something should happen, can you talk about that more? Because you're the expert.
Yeah, no, thanks for bringing that up. And it's actually, we see that as an emerging trend among young couples today, is keeping their finances actually quite separate.
Right.
And, you know, I'm not going to talk about how I feel about that in particular, but from a legal standpoint, if you have your own bank account and you die and you haven't taken proper measures to ensure that your spouse has access to that account's going to go through probate. Even though you have a trust, if you haven't put that account in your trust, if it's your separate, this is mine, I don't want to, um, the courts are going to get involved. And what will happen is the bank will freeze that account. As soon as they get word that that account holder has died, they'll freeze it.
Well,
We've even seen banks freeze accounts when there are multiple signatories on the account, because they don't know, the banks don't know what legal challenges are going to come their way about those funds. And so even with a married couple, sometimes where you said, I'm going to add my spouse to my account, I want to make sure that he or she has access to it. Often the banks will freeze one half of that account that belong to the spouse that's died, because they don't know if there's going to be legal challenges to that. That's one of the other benefits of having a trust. When you make that account a trust account, a lot, those risks go away. And so, yeah, there's uh, definite risk in how you decide to manage your finances as a couple. And so, that's one of the things we like to talk to people about and find out, if that's your value, that's fine. If you want to keep your finances separate, I have no opinion about that. but think about the implications that could potentially arise.
Excellent. Thank you. Next question is, does one need an attorney to establish a trust or a will? Why or why not?
Man, this question is so relevant to today. With generative AI, Chat GPT, that type of thing. So many people are getting it in their mind that I can just, write in, put my prompts into Chat GPT and say, create a trust for me. This is my family. These are my children. Um, and it's really scary. The precursor to that is all these online wills and trust services that you can go in and you can pay $195 and put your information in. It'll spit a trust out for you. There are financial advisors out there who are promoting form trusts. We'll just get a trust to avoid probate, and they'll plug your information in. So can you make one without an attorney? Absolutely. The key here is that in order for your trust to fully serve your family and to protect your assets and to accomplish what you really want to accomplish in your family's life, you need the advice of a good legal counselor who can help you make the best decisions and who can bring up potential issues and concerns that you're not going to think about. And I would even go so far as to say that there are a lot of estate planning attorneys. If you go out and you Google estate planning attorney, you'll find hundreds of them on the internet, and they'll have very beautiful websites and very impressive. I would encourage you to not take at face value that they're going to provide you good legal counsel. I review trust for people all the time who bring them to me. So, well, I had this trust created, by this attorney up in Phoenix or Tucson or Flagstaff, and could you just take a look at it and make sure it's okay? And when I go through the review with them, often they're like, "Well, why didn't anyone ever tell me that? I I I didn't know it said that."
Right.
And so what we find, and I had this just happen just the other day. Um, we had clients who their estate's probably worth about 12, $15 million, and they brought their trust in for me to review, and they were just lifting their jaws up off the floor, about what the thing said. And this is what the guy told me. He said, I sat down, I talked with the attorney, and he asked us what we wanted and what we had and about our family. And then when we went in to sign, he handed us this trust and said, okay, this is exactly what you need. And we signed it. He said he never really went through it and told us what everything meant and how it was going to impact our family.
Wow.
And so, what I would say is, find an attorney that, interview them and ask them, how do you practice? Are you going to, sit down and really work this through with us and give us counsel and advice and help us make the right decisions? Are you going to explain this plan to us when we get finished? Are you going to explain it to our family so our family understands it? And find an attorney who'll do that. Don't just find the pretty website. So can you make one without an attorney? Yes. There's nothing preventing you from doing it. There's certain things you have to sign it. It has to be notarized, and that's fine. But will it serve you? And more likely than not, it will not serve your wishes and could actually cause more harm. The other thing that is even more important, I think sometimes, is when someone comes to me with a trust and they say, "John, will you review this trust for us?" The first question I ask them has nothing to do with the language in the trust. I ask them, have you retitled all of your assets into your trust?
Mm.
And because a trust is only as good as the assets that it holds.
Wow.
And so, so often I get, this kind of blank look, like, I'm not sure what you mean.
Right.
and they have had this trust for 10 or 15 years, and their home is not retitled to the trust, their bank accounts are not in the trust, their vehicles are not in the trust is not a beneficiary to their retirement plans, and they've had this false sense of security all
Mm.
this time that they have this trust and it's going to work for them, and it's absolutely not going to work for them, and their entire estate's going to go through probate, and it's not going to go to their children the way they want. So creating a trust, there are documents. Trust documents need to be well prepared, and they need to be prepared with a lot of thought and counsel from a professional. But it's just those are just the documents.
Right.
We have to build on those documents to really create the plan that we need, and make sure we have assets transferred, and we talk to the family, and we educate all the different people that are involved, so that when that time comes, everyone knows exactly what's going to happen.
I remember when you were helping my family get ours set up. I was thinking that the trust was going to be something we could put in like a little folder, just kind of slide it into a filing cabinet. I bought a special safe for it. And once you did bring our trust folder, it was like 4.5, 5 inches, because there was so much that I didn't even think that were going to need, that I didn't even think that was going to be in it. And as you went through it, and you and your sister started telling us the different things that we would need and why it was done this way, it was like, oh, stuff I never knew that I didn't know. You don't know what you don't know. But it was
Right.
so many things that you were able to bring to light for me and my family, that and we actually have looked on some of those online web things, just to look
Mhm.
up things, and it was like 4 or 5 pages for those things, whereas
Right.
what you brought me was 4 or 5 inches, kind of, and but it was everything that we needed. So I agree that there's so many things that you helped us to understand, me and my family understand, that I would have never understood had I not spoken to you.
Right. And that brings up actually like a whole nother component of this is, um, sometimes clients look at us kind of like, why do I need 200 pages of documents? And like I said before, is my philosophy is that we build a safety net for your family that doesn't have holes in it, and that will serve every aspect of your family, throughout your life and future generations.
Right,
But so many people like yourselves who also have business interests,
right.
and that's another huge part of what we do, is make sure that those business interests, that we have succession planning in place, and that they're properly established, to maximize tax savings, and to maximize liability protection. So all of that is important also. It's all part of that whole plan. So anytime you have somebody with a business interest, that just adds a whole nother element. And we talk about, can you create your own trust? The same thing. We have people going out and creating their own LLCs, and it's easy. You can go onto the Secretary of State, Arizona Corporation Commission, and you can, for about $35, you can fill out the forms and pay your money, and you have an LLC. But all you have are documents.
Mhm.
And so the same thing holds true by going to like an online document site, like or Trust or Will. All you have is a document, and you're basically filling in the blanks. So what we know, to compare that, for example, to an LLC or a business interest, you have to have the documents. You can't have the business without them.
Right,
But creating asset protection for your personal property with that limited liability company requires work, and there are things that you have to do using those documents as a foundation to actually get that protection. So uh, that, I guess I kind of use that to kind of do a comparison of
mhm.
what happens when you do your own will or trust online, and what happens when you form your own LLC online. You have documents, but they may or may not work for you.
question. You talked about retitling and making sure that you have assets within your trust. So the
Mhm.
next question is, what property can go into a trust? But what is it? I want to also, in addition, ask, what does it mean to retitle something? What does it mean
Sure.
to put an asset into the trust? Can you define that for us?
Certainly. So any asset, um, other than like qualified retirement plans and certain life insurance policies, can go into your trust. Now, that means your home, your bank accounts, your personal property, your business interest, your vehicles, collections, all of that should be contained in your trust. And I'll talk about how that happens in just a moment. There are certain things that we cannot retitle or place inside the trust because there will be some tax consequences or some other consequences that are not favorable. For example, if you have a retirement plan, that is your personal retirement plan, and you can't retitle that to the trustee of your trust without causing some income tax problems, some premature distributions from your plan. And so we don't want that for you. And so we'll say, okay, that does not go in your trust. A term life insurance policy you cannot put in your trust. However, if you have a universal life insurance policy, then we will talk to your life insurance agent and we'll discuss whether it's appropriate to retitle that, change the ownership from you personally to the trust. And just a very quick aside, I'm very hesitant to uh, make a lot of decisions like anything with retirement plans, investment accounts, uh, life insurance, without consulting with your other advisors.
Right.
This is a team approach. I am not a tax attorney. I'm not a financial planner. I'm not a life insurance agent. So you have a team. I say that to include everybody. You have a team. You have life insurance and financial planners and accountants, and together we form your advisory team. And from my perspective, I can handle the legal part, and I'll consult with your financial advisor about what assets to put into the trust and which ones to leave out. I'll consult with your life insurance agent about how to best do that for you. We'll consult with your accountant about what's best for you in your trust. So it's always a team approach. So what it means to retitle is, I'm going to take an example of a home. If I own my home as belonging to John Hilton and my wife as community property with right of survivorship, um, that's not in the trust, right? So
Right.
retitling it is simply a matter of creating a new deed and recording it with the county that transfers title to John Hilton and my wife as the co-trustees of my trust. It's a simple change in the name of how it's held. And once you do that, that house now becomes a trust asset.
Mm.
Same thing with bank accounts. You go into your bank and you own your bank. Maybe, Damon, you've got your account in your own name and you want to put it in the trust. You say, hey, I got this account. It's in my name. I want to put it in my trust. Here's the name of my trust. So I want to retitle that account to say, I want it to be Damon as the co-trustee of my trust.
Mm.
And that moves it into the trust. So it's purely a matter of how ownership title is held to the asset. Same thing with your vehicles. You can go down to the MVD and say, we own this vehicle as, and but we'd like to put it in the trust. And so you do a transfer of title to you as the co-trustees or the trustee of your trust, and it becomes a trust asset. So that's what it means to retitle the assets. What we see often happen is people will transfer their home into the trust, but they will unilaterally make the decision that, I really don't want to mess with my bank accounts, so I'm just going to leave them out. I just don't want to deal with that. And we sell and buy our vehicles every 2 or 3 years, and it's just too much hassle. I don't want to put those in the trust.
Yeah.
What happens then is if there's a death in under Arizona probate law, if your personal property is valued at more than $75,000, it has to go through probate.
Mm.
And so, what does a new truck cost these days? $80,000, easy, you
Easy.
know?
Yeah.
So you got this brand new truck and you're like, oh, I don't want to put it in the trust. Well, guess what? Now you've created a probate situation for your family.
Right.
And so I always say, a trust works when all of your assets are in the trust. You're going to avoid probate. All those assets are going to flow to your beneficiaries the way you want. When you make these decisions that, well, I don't want to give up control of my bank account by putting it in the trust, you're just creating problems for your family. And so one of the ways to look at it, when you transfer or retitle assets to the trust, you're putting them under the control of the trustee of the trust. The trustee of the trust has the authority to buy, sell, give away, whatever it is, that asset. And as long as it's your trust, you're the trustee and you're the beneficiary. So you have total control. At some point in life, if you become incapacitated, you've named someone you trust who can step into that trustee role and manage that asset for you. And they have a legal and fiduciary duty to manage that asset purely for your benefit, to take care of you. They don't get any benefit from it. And that scares some people.
Mm-hmm.
And so what I try to kind of sometimes equate it to is the difference between leasing a car and buying a car. You go buy a car, you get the title in your name, and you have total liability, you have total control, you can sell it, whatever you want. When
Right.
you lease that car, what changes? Well, the only thing that really changes is that your name's not on the title.
Right.
It's still titled to that leasing company. But do you get full benefit of the use of that car? Absolutely.
Right.
You can drive it however you want to. You can do upgrades to. You can do whatever you want to. There might be some penalties, if you abuse
Right.
that privilege. But
Right.
it's your car for all
Right.
intents and purposes. You have the full benefit of it.
Right.
And so when people talk about, well, I don't want to give up control, I just remind them, well, in the event of your incapacity, you are going to give up control.
Right.
You're either going to give up control to someone that you name in advance, who you trust to manage that asset for you and to use it for your benefit, or you're going to give up control to someone that you don't have control over, that you don't know who's going to be, and you don't know whether you can trust them or not. So that's kind of a little rabbit hole around retitling, but that's kind of what it's all about.
No, that was excellent. And that last little bit there reminded me of something that happened to me when I was working as an insurance agent. There was a situation where there was a young man who had a large life insurance policy. He and his wife had divorced, and they had 3 children together. He and his wife divorced, and they have split custody. Well, on his large life insurance policy, the only person he felt like he could trust to take care of his kids are obviously their mother.
Right.
She's remarried with somebody else and has other kids with this other individual, but she's still the beneficiary on his life insurance policy. And
Yeah.
he was like, I don't know what else to do in that situation. And this would be a perfect instance to say, hey, would you agree with that assessment or no?
Absolutely. A perfect example of, as a life insurance agent, when you're faced with that, if you say, look, this is not ideal.
Right.
First of all, um, life insurance proceeds are taxable, income tax. And so someone's going to pay income tax on those. And there's no guarantee that that money is going to go to your kids.
Right.
That money could easily go to that new spouse, those new kids. We hope that mom is responsible and wants to take care of her kids,
Right.
but life has a way of sometimes warping our values, and so you can't rely on that. That's a perfect opportunity for a life insurance agent to say, look, why don't I put you in touch with somebody who can help you ensure that that life insurance will go to your children. We set it up through a trust. Life insurance proceeds go straight into that trust, and your trustee, who is not going to be your ex-wife, who is somebody else you trust, will make sure that that life insurance payout goes down to your children the way that you want, and it's there to take care of them. Um, and it's a perfect example of why a trust could be beneficial in that situation.
Excellent, excellent. Thank you for that advice. I'll make sure if I run into that individual again to let them know.
Yeah, yeah, for sure. Life insurance beneficiaries I talked briefly about this before, but it's such a hard thing when you have minor children and an ex-spouse. You want to believe the best,
Right,
but we have people who have taken their very substantial life insurance policy and named, for example, their sister or their brother as a beneficiary with a promise to take care of their children if anything happens.
oh wow.
Well, you know, okay, I trust my brother, I trust my sister. They won't let anything happen to my kids. All right, great. So your brother or sister just got a $1 million life insurance payout. What's that going to do to their income tax for that
Right,
year? It's going to
right,
be significant. So a
right,
large portion of that payout is going to go to taxes.
right.
And what happens if, despite your trust and confidence in your brother or sister, at that particular time, they just happen to be about to lose their house? They've hit hard times, they've lost a job, the mortgage company's knocking, they're threatening foreclosure, and they just got this payout. You know, are they going to use that money to bail themselves out of that situation? More than likely, yes.
Right,
And they'll justify it. They'll say, well, my brother would want me to do this
right,
because how else can I take care of his children if I'm homeless? You
right,
know, and so it's just things like that. Or what happens if that brother or sister gets that payout and 3 months later gets divorced?
right,
Is that payout going to be separated as separate property, or is it going to get caught up in the community property dispute?
right,
Um, and so people do these things out of not knowing.
right.
And so, yeah, just a little bit of investment of time and money and putting into together a trust, and all that goes away, um, all that uncertainty.
Excellent. Thank you for giving me that advice. That's good stuff. I can pass it along.
Yeah, of
Uh,
course.
we're winding down here, so but I do have to ask this question: what are the downsides to a trust?
Okay. Yeah. So the downsides, it's a little bit more investment than doing a will plan. There's a lot more legal counsel and drafting, and a lot more goes into it, and a lot more value to the client in most cases. So you're going to invest a little more up front. There's the aspect of that emotional, um, I guess I don't really know how to say that emotional tug that I talked about before, of not having direct ownership of your assets, that they're owned as in the trust by a trustee who happens to be you, but may not forever be you. And some people have a hard time getting past that.
Right,
At death, certain trusts become irrevocable. And once a trust becomes irrevocable, meaning it can no longer be changed, it's whatever's there is there, and nobody can change it anymore. It now becomes a legal entity, and it has its own tax ID number and has to file its own taxes.
mm,
So, other than that, life goes on. It's no different. Once you have your assets, retitled to your trust, that trust becomes just something in the background. You're not having to think about it. You're not having to, your annual tax return doesn't change. It's considered a see-through trust. The IRS doesn't care if you have your assets in a trust or not. You're still filing your taxes under your own social security numbers. Um, so the only thing that changes is when you buy a new vehicle. You just have to remember to tell the guys when they're filling out the title, hey, don't put that in my name, put it in, here's my trust card, here's the name of my trust, title it to my trust.
right,
You sell and buy your house, you've got to tell a title company, whoa, no, I don't put it in my name, put it in the name of my trust. If you forget, it's a simple matter of doing a new deed and re-recording it and getting it back into your trust. Um, Other than that, I mean, it's really difficult to find any downsides, especially when you compare them to the benefits.
Right, right. And I totally agree with that. It's funny when you mentioned the whole emotional tug kind of thing. I remember I experienced it
You
because
did, yeah.
because I purchased my home before we got married, so it was solely in my name. I
Mhm.
think one of the cars was solely in my name, and so I'm like, man, I don't own my house anymore. And you're like, no, you still do. I'm like,
Yeah.
but it's just one of those things where I'm like, oh man, like I'm putting, but then afterwards, I was just like, that's silly because why shouldn't it be for both of us anyway? So, you can get people can get over that. It's just a matter of mindset, I think.
Yeah, and it's just a matter of being able to talk it out and explore the emotion.
Right.
And then, to that point, though, we do have couples who come in, and especially older couples who maybe are blended families, and wife comes in and says, I own my home. I've got a $450,000 home. It's mine. I when I divorced my first husband or spouse, this became my house. My children were raised in it, and I want it to go to my children. I don't want it to be part of the community property.
Yeah.
And that's fine. We can actually, in the trust, we can keep that as this separate property of that spouse within the trust.
Mhm.
And so, just because it goes into the trust doesn't mean that it has to become community property. It can
Right.
maintain its separate property status. So that's always the option of the family when they have separate property. Do we want to mingle this and turn it into community property within the trust, or do we want to keep the separate property? And so, absolutely, and that's important sometimes when we have couples who are bringing separate property in, and then they get divorced, and now they got everything in the trust. And so, if we can kind of keep things properly titled within the trust, uh, that that division of assets, if that couple gets divorced, is much simpler as well. So like I said before, every family has a story. Every family is different, and that's why you going back to one of your previous questions. I think why it's so important to have not just an attorney help you with your trust, but have a counselor
Mhm.
who will sit down and help you work through these questions and these concerns and these issues, and then help you make the best decision for your family.
Excellent. So before we end, I want to know: is there anything else that you've thought of through the course of this interview and conversation that you might want to highlight, just to make sure that the watchers and the people who may be listening to this, they still have or they have a understanding of what you're trying to say, or anything you might have missed?
Yeah, well, let me just kind of put a cap on it.
Okay.
Um, Bottom line is that if you are 18 or older, you need to have some bit of a plan in place. You should at least have healthcare directives and financial power of attorney. If you are 18 or older and you're single and you have assets, you've bought your own home, like Devon, you had your own home and you had your own car, then you need a plan in place. If you don't have a plan, then and you die, your assets will be distributed according to the Arizona statutes. It's called intestacy. And your assets will go to whoever the statutes say is next in line for you. That could be your parents, it could be a sibling, it could be nephews and nieces. Um, and that all just kind of goes back to the statutes. If you want any control over where those assets go, you need to get that documented either in a will or in a trust. If you do not want your loved ones, your family members going through probate and having to deal with the court oversight and the appraisals and the family conflict and strife that comes along with it, the time and the money, then you should really consider doing a trust. If you don't have enough assets that's an issue for you, and you prefer, that's okay to have, then at least do a will so that you have control over where your assets go. Everyone over 18 should have power of attorney and healthcare directives. If you have children, you should make sure that you have a plan in place to make sure that your children never end up in the home care custody of strangers. That if anything happens to you, they are always in the care of people that you know and trust to love and care for your children. And if it's a permanent situation, that they will raise your children according to your values, spiritual and financial and social. Um, I think that kind of, is my message is it's never too late and it's never too early. Um, and what I hope is that through listening to this, that you're stirred to make a decision about your life. It's either a decision to wait, it's a decision to move forward, but make a decision about what's important for you and what you need to do to protect your family. Um, and other than that, I just say uh, I'd love to work with you, but there has to be a good fit. And if you want to work with another attorney, that's fine. I'm here to educate people and inform people and to provide my services to anyone who feels like I'm a good fit for their family. But if you don't use me, please, find someone who's going to provide you with the right counsel and help guide you through this process.
And so anybody who's in Arizona or anybody period, can they come to you, or is it specifically for Arizona? Who should be reaching out to you?
So we work throughout the state of Arizona. Our office is in Cochise County, but we are able to help people throughout the state. Um, we are also able, if you're in another state, absolutely give us a call. And if we can't help you, we will refer you to another trusted attorney in that state and make sure that you get in the care of somebody that we trust. So we would treat you just like you were ours and make sure that you're in good hands if we're not able to help you.
Excellent. So, family, I've been speaking with Mr. John Hilton. He is a life and legacy planner. He is with the Tierra Bella Law Group. This is their website. He has helped me and my family, and he's helped us tremendously. It has been an excellent, or I shouldn't say ordeal. It's been an excellent process that we've gone through, because ordeal and denotes badness, but it's been an excellent process for us. He helped me and my family, help our legacy, secure our legacy, and it has been awesome. I highly recommend him for anybody who's watching this. Get in contact with him. The number is at the bottom of the screen, 520-428-1188. It is it's been a pleasure to speak with you, Mr. Hilton. It's been a pleasure to do business with you or work with you or have you help me and my family. And I hope we have more dealings in the future.
Likewise, Damani, I absolutely loved working with you and your wife, and it was such a pleasure to work with you guys. I love your spirit, both of you, just so full of life and your vision for your life and for your world and the impact you're going to make on the world. I can't wait to see how that continues to evolve. Um, and, we're yours for life, right? So we're going to be coming after you
Yes, sir.
every year or two. Hey, Demond, Teresa, hey, has anything changed? Did you start a new business? Did you, sell a house? Did you, anything changed in your life? Because we want to make sure that that plan always works for you. And that's true for all of our clients. Our goal is not to ever hand off a binder of documents and say, hey, good luck. We consider ourselves yours. Sometimes, whether you like it or not, we're going to be after you until you tell us to leave us alone. So, our goal is to make sure that your plan works today, and that it works for the rest of your life. For your family, as your lives change, as the laws change. That yeah, you talked to mine about you were expecting this thing to kind of put in an envelope, put in the drawer, put in the safe. um, you know, the reality is that this is called a revocable living trust,
Right.
and what that means is that throughout your life as your life changes, this plan grows and changes with you.
Right.
So don't take your plan and stick it in the safe and forget about it, or stick it on the shelf, or and it's like, well, that's done. I've checked that off.
Right.
You checked it off for this year, but now for the rest of all of our clients for the rest of their lives. Every once in a while we're going to bring it out and say, hey, Is this still good? Are these still the right people that you have named? Has anything changed that we need to address? It always works for you.
Excellent. It's been a pleasure. Thank you so much for your time, sir.
Pleasure is all mine, Damon. Thank you so much.
Yes, sir. God bless you.
You too.
Bye-bye.
Bye.